Ashley Hurd, founder of Manager Method. I'm an employment lawyer and a former head of HR, and I'm breaking down the U.S. Federal Trade Commission, FTC, proposed ban on non-competes and what you need to know. I'll talk about timing, what's covered, what's not covered, and what to potentially expect next. So as heads up, in July 2021, new President Biden had issued an executive order, and as part of it, he directed the FTC to look into addressing unfair competition through non-competes. And that was really it. So for the last year and a half, the FTC has been doing listening sessions, having studies, looking at data to determine unfair competition. And the question is, why is the FTC looking at this and not something like the Department of Labor? Well, the FTC, part of what it covers is unfair competition. This is through the FTC Act. Because people ask, what about Congress? So there are federal agencies, FTC is one of them, and they get their power through Congress. So in the FTC Act, one of the things the FTC can do without further congressional approval is to address certain aspects of unfair competition. Now we'll talk about what to expect next and whether this ban on non-competes is within the powers that the FTC has from Congress or not. But it all circles around unfair competition between businesses and people moving around jobs, or labor mobility, as some people call it. So over the last year and a half, the FTC has been doing all this background work. So yesterday, they issued their proposed rule. Now notice the proposed rule is not that long, but what they issued was an over 200-page document that goes through all of their background and different studies and how they got to the different aspects of their rule. I read through it so that you don't have to, but I will link it in the show notes or the comments. So in this rule, what happens next from timing? Nothing happens now because it's just proposed. So over the next 60 days, there's a comment period for the public. That means U.S. So oftentimes it's organizations, the Chamber of Commerce, unions, law firms, but the general public can add comments as well. So I'll also link in how you can do that. So issue comments, they'll take that in. Again, while that can potentially get extended, what will take a long time is for the FTC to look at all those comments and decide what changes, if any, to make from their proposed rule to the final rule. And so once the FTC then issues their final rule, what happens then is about a 60-day period called the effective date, but then there's 6 months after that employers have to comply. We'll talk about what they have to do. So what that means for you is that nothing happens yesterday or today, and nothing would happen until the end of really 2023 at the earliest. And we'll talk about what's to come because it's likely going to include litigation. But what it covers. So one thing to note is that the FTC actually is not affecting all industries. And it's not a limitation on companies. Sometimes agencies will put out a rule and it will apply only to companies with a certain amount of revenue or things like that. The FTC had this ban on non-competes affect every company that's within the FTC Act. And that's basically most private for-profit companies, meaning not government agencies, they're not covered, not nonprofits. But interestingly, a couple industries, like certain banks and savings and loans and air carriers are not covered by the FTC Act. So one thing to know. What happens with those industries, I'll leave that to the FAA or whomever. But so the FTC actually doesn't cover all, but it does cover most companies. But interestingly, again, they didn't make an exception for small business. So they didn't say companies with different amounts of revenue, and they didn't say companies with certain numbers of employees. And they said they specifically looked at carving out small businesses, but did not. So this would impact all employees of an organization, which is really interesting because as written right now, it affects the janitor up to the CEO alike. The only exception is for business owners and partners. And in the proposed rule, it has to be a partner of 25% or more. So some people will say, what about doctors' groups or things like that? Well, if there's 5 or 6 or more equal partners, that's less than 25% shares. So they would still be covered. Again, that could be changed in the final rule, but right now it affects every employee. Also, it impacts independent contractors, which is really interesting because right now, another priority in President Biden's administration is addressing misclassification, meaning when organizations classify employees, people that are really employees, as independent contractors for cost savings or whatever reason. And so the FTC specifically said it applies to employees and independent contractors because they don't want to encourage companies to further classify individuals as contractors more. It also applies to interns, externs, anything like that. So basically anyone providing services and sole proprietors to a company. So it would be a ban on non-competes. That means the ability for somebody to go and work at a competing company. So if I, Ashley, have a business and I say, you cannot work at a business that's in a similar industry as mine, and my next door neighbor, Jan, owns a similar business, then an employee of mine couldn't go work for her. It couldn't work at all. And so that's what it's addressing, is that non-compete aspect. So it only affects non-competes. And what it would mean is it would invalidate every existing non-compete and all future non-competes. And also, it would make employers have to notify employees or anyone, independent contractors, under a non-compete now that that no longer exists, which is really interesting because the FTC said they don't want employers to say, well, we just won't tell employees so the employees don't know, because part of the FTC's rule was they said that a lot of employees have no idea whether they're under a non-compete or not. So it's three things: invalidates old non-competes, prohibits future ones, and requires employers to let employees know. They will have a proposed notice for that. But it is interesting to know. So it would not affect non-solicitations of customers. What that means is if someone doesn't have a non-compete, so they could now work for Jan, but if I have say, well, if you worked for certain customers for me, you can't go and call on those customers right away for Jan. You have to wait 6 months, 12 months, 2 years, whatever. That wouldn't necessarily be impacted, the FTC says. Businesses can still have non-solicitations of customers, but if they really are like a non-compete because they're so broad, then that would be covered. So that's an aspect that would have a lot of questions. Where's that really line? That turns a non-solicitation of customers into a non-compete. Same thing with confidentiality agreements, that you can still have confidentiality agreements. So I can say, I have this customer list. You can't take that and use that for Jan if that's private information that's not public. And so that you can still have non-solicitation of customers and confidentiality as long as they're not so broad to be a non-compete. You can also, it doesn't impact non-solicitation of employees. So if I say, employee, you're leaving me, you're going to work at Jan's company, you can't poach people that used to work for me. It doesn't impact at all on non-solicitation of employees. FTC specifically says that. So what's going to happen next is during the comment period is they'll decide whether to make any decisions and changes to it. So it was a dissent. A member of the FTC issued a pretty scathing dissent in two things. A lot of comments are going to be echoing this. And also if there is litigation, you can look to it that it's going to track what that said, that basically FTC does not have authority to do this. This is outside the bounds of unfair competition. And so that's when you see those comments, a lot are going to be citing that same logic. So you can look up FTC dissent. I'll also, again, include that in the comments. But where you might see changes. So the FTC basically hinted in a few places they'd be willing to consider. One, carve-outs is for executive level employees because they say it's bargaining power. So executives can negotiate that much more than others can in their roles. So that may be a carve-out that they allow for non-competes at certain executive levels. And they've said that could be over a certain compensation amount, like if you make $100,000 or more, for example, just as an example, or if you're classified as an executive or a learned professional under the Federal Fair Labor Standards Act, which means you're like truly a managerial employee, not just that you have manager in your title, but what you really do, or also learned professional, like as a lawyer, have a bar license, and things like that. So there could be some carve-outs down the road. They've also said they'd be interested, potentially considering what's called a rebuttable presumption, which would mean that non-competes are still legal, but they're presumed to be invalid unless a company can show clear and convincing evidence that they are reasonable and necessary, basically. For me, I think this would really just invite a lot more confusion. I see why they're trying to find some middle ground, so I'll be interested to see if they do that. And they've said they'd be willing to consider that across the board as opposed to a ban. So again, you can still have them, but you got to prove they're reasonable and necessary, which I'm sure a lot of lawyers would be interested in. They've also said they'd be willing to consider that at a certain level. So what you could see is that non-competes are banned up to, say, a certain compensation amount. Then above that, they're presumed invalid unless they're shown that they're really necessary. So that's what you might see. So they've outlined some of these potential alternatives as well. So all of these are next steps that you'll see with the proposed rule. So I'm trying to think of anything else to cover in this, but it is really important to know, again, nothing happens today. It's all subject to the comment period and final rule. So employees who are looking at their non-compete, there's nothing to truly be done until that final rule comes out. But for employers, it's really important to think because non-competes have been a stick that have kept employees in line, or not in line, in place. But a lot of places either don't have them or have restrictions. California, South Dakota, Oklahoma don't have those. And so there, a lot of businesses have to use carrots. And so that's why I say employers should, it's long past time to be thinking about what you're doing to keep employees staying and also engaged, not just relying on non-competes to prevent people from leaving. So happy to do a follow-up if there's any additional questions, but wanted to provide this a little bit more insight so you don't have to spend time reading through a 200+ page document.